Okay, so this is going to be a pre-recorded lecture. That's the iFlex method, and that's how this class is being delivered. So away we go, agribusiness students. My name is Richard Opie. I'm the paralegal program director, and I was recruited to teach this class because I'm also an attorney. Truth be told, I have not done a lot of agribusiness, but I taught this class last spring, and I found that a lot of it dovetailed with my knowledge, and I learned a lot. So hopefully you'll learn a lot too in this class, and I always like getting feedback from students because you folks are on the front lines of agribusiness, and so you've got some great stories to tell that we can share in class and sort of analyze issues that come up from time to time. I'll have at it. You guys are supposed to watch these lectures, and then we talk about them during class time. So the class time, the actual in-class time, is shortened, but you're expected to watch these. So away we go. So the first day is really sort of an overview of our legal system, and that sets the groundwork for a lot of the topics that we talk about going forward in the course. So first up, our system is complicated. The United States legal system is fairly complicated. We've got a federal system, which means we have a federal government. The federal government oversees the entire country. But under our Constitution, states have a fair amount of power, unlike a lot of other countries. Some other countries are under what's called unitary rule rather than federal rule. So in other countries, marijuana is illegal, either illegal or legal throughout the country. They have the death penalty, either throughout the country or they don't. On the other hand, in our country, each state gets to decide certain issues, such as the death penalty or whether marijuana is legal or not. And we can get into that. We'll get into that in more detail. And then there's some overlap. And for example, a lot of ag law, for example, environmental law, there is state rules, and then there's also federal rules. And the federal rules are supreme. Under the Supremacy Clause of the United States Constitution, Article 6, federal law is supreme. But there are some areas that the Constitution doesn't give the Congress the right to pass laws. Marriage is a good example. Each state has their own marriage laws, the age at which you can marry, and so on. So some of that we're gonna sort out through the course of the semester, and then of course overlapping that, you've got county government, county regulations, and we also have Indian tribes that have their own law as well. So as I mentioned, we've got our U.S. Constitution sort of lays the groundwork for what states get to decide, what the federal government gets to decide, and then what the overlap is. The other thing, an introductory point about American law is that we inherited something from the English. Of course, we used to be English colonies. We inherited something called common law, and that is law made by judges. Examples of that would be our negligence law. When you get in a car accident, what are the rules about negligence? Contract law, which we'll talk about, that obviously affects agriculture. Contract law is common law, made up by judges. A lot of times when we think of law, we think of statutes, which are passed by the legislative branch. Or we think of regulations that are passed by regulatory agencies. Or we think of constitutional law. Okay, we can talk about what are your constitutional rights. One area of the law that a lot of folks aren't really aware of is that there's a whole body of law called common law that is made by judges, something called precedent. When a judge makes a decision, that decision sets precedent, and then going forward, that decision is the rule. And any subsequent circumstances that arise that are similar to those circumstances in that case must be treated the same. That's precedent also known as stare decisis. That's the fancy Latin term, which simply means let the decision stand. Let that previous decision stand, and then going forward we'll do the same. Civil law is a whole body of law, and then we're going to spend the majority of time in this class on civil law. And the really dividing line there is either it's criminal law, so that involves crime. The district attorney is in charge of enforcing those laws. Civil law, on the other hand, the government enforces that through agencies, or we can enforce it ourselves. If someone breaches a contract, the district attorney is going to sue the person who breached the contract against me. I have to do that myself. So civil law, negligence, property law, contract law, and copyright law and things like that, and all the regulations that ag business has to deal with is civil law, largely civil law. Now there are some criminal potentials in the ag business depending on the egregiousness or the severity of the behavior, but most of the time we're talking about civil law. And then, as I mentioned before, the regulations, which is called agency law, all those, that alphabet soup of agencies, we've got a few up here on the slide, USDA, EPA, FDA. My gosh, the amount of regulation that governs the ag business is rather extensive. And I know that bothers a lot of people who are in the ag business because they've got to follow so many laws. But one of the things to remember about the ag business is we're talking about feeding people. And the potential for harm on a mass scale is big. And so I would say for the first 150 years of our country's history, there wasn't a huge amount of agricultural regulation. But when agriculture got industrialized and food production was industrialized, suddenly the potential for harming, a mass number of people, if there's a serious flaw in food production or in the food chain, gave rise to ever-increasing regulations with regard to food, and of course lots of other products. So it's just something that is a reality that we have to deal with. And again, that's something that it's burdensome. It costs money. It adds to the expense of running an ag business. But there's no getting around it. You need to be aware of it, and you need to deal with it. Oh, come on, let me go back. Okay. So start with the Constitution. Not letting me go back. Please let me go back. All right, we're still not getting there. It's just moving me forward. So let's see what we can do here. Okay. All right, guess we're back here. So Constitution is the primary document, the highest source of U.S. law. You may have questions about that. We've had a lot of discussion about the Constitution and how it works and how it applies, maybe in the context of wearing masks, maybe in the context of impeachment. So we can talk about that in class. But it is the highest law in the United States. No law can override it. No law can conflict with it. And so if anybody, state or regulatory agency, passes a law that conflicts with the Constitution or any of the constitutional provisions, you can challenge that in court and have the law declared unconstitutional, which has happened numerous times in our history. Maybe you can think of a couple examples of that. Famous cases that changed really the course of our society. It also, as I mentioned earlier, divides power between the federal and the state governments. Lets the state governments do certain things. And then lastly, the U.S. government has limited powers, although people would argue with that. Over the years, it's gotten more and more power. But the idea is, if you take a look at the Constitution, Article 2 or Article 1, Section 8 is a laundry list of what the Congress can do. Anything not on that list is arguably the responsibility of state governments. So one thing that comes up when you have a conflict between federal and state laws, sometimes states want to regulate in an area, and the federal government also regulates in the area. We end up having a fight. We end up going to the court, and the United States Supreme Court would ultimately decide who has the ultimate authority. But if the U.S. Supreme Court decides that the federal government has authority in that area, they can say that the state law is preempted. In other words, the state law is not enforceable. It can expressly preempt. For example, if Wisconsin decided to coin its own money, the Constitution specifically says that the state of Wisconsin, that the federal government shall coin money, so that would not be a problem at all. That would be an easy one for the Supreme Court to say Wisconsin's attempting to make its own money is preempted by the Constitution. Also, then this should be statute, not statute. That's a common error in the law that we miss that T. A statue's, you know what a statue is. But anyway, it should be statute with a T. And sometimes when Congress decides to take charge in a certain area, it's said to preempt that area, and that means states cannot regulate in that area. So there's overlap sometimes. An example would be minimum wage. The United States Congress passed a law that set minimum wage at $7.25 an hour. But when they passed that law, they did not expressly preempt states, in other words, prevent states from passing their own minimum wages as long as the minimum wage in a particular state was higher. So some states have a minimum wage somewhere in $10 an hour. I believe Wisconsin's minimum wage is still $27.25. Our state legislature has decided not to raise it over $7.25. And there's some exceptions to that, of course, agriculture and other things. You guys are probably aware. So the Congress could expressly pass a statute that says that the minimum wage is $7.25 everywhere and nobody else can change it. Or they can set baselines. Environmental regulations, which affect agriculture quite a bit, of course, they did not preempt other than letting setting a baseline. States can have more restrictive environmental regulations. And if you look at a lot of products, you'll see California, the state of California, they have fairly stringent environmental regulatory rules. And so a lot of times they go above and beyond what the feds do. So there's also statutory preemption. And then it gets a little bit more, down in the weeds there with implied preemption. Some statute expressly preempt. They say this is the rule. And then courts also have to decide whether or not, based on the language in the statute, did Congress intend to preempt? That gets a little trickier. But oftentimes we'll have, federal law and state law in conflict. And courts are the ones that are, in charge of resolving that conflict. A good example of that is the marijuana laws. Under federal law, marijuana is still possessing marijuana and growing marijuana is still a crime under federal law, and you're all aware that a lot of states are allowing that. The federal government has basically decided not to enforce that law except under certain circumstances. But there have been Supreme Court cases that said federal law preempts state law when it comes to the regulation of drugs. Drugs are part of commerce. The Commerce Clause gives Congress the right to regulate commerce. So the FDA, Food and Drug Administration, still has marijuana on the books. as an illicit substance, but the federal government has decided not to enforce that rule. So a little more on the Constitution. It's not that long. Well worth pulling it up on the internet and reading it. It's 7 articles, and it basically lays out the power of our government. Article 1 is Congress sets up our bicameral, our 2 houses, the House of Rep and the House and the Senate. Article 2 sets up the executive branch, and Article 3 sets up our judicial branch, the Supreme Court. So it's those 3 articles really outlay the structure of our government, and the other articles give us some rights, due process rights, as well as regulate the federal government and what it can and cannot do. Then there's amendments to the Constitution. So we had our original Constitution with 7 articles. The amendments, 27 of them in over 200 years. The first 10 were all passed at once, and that was a whole slew of rights that citizens have. In other words, the original 7 articles laid out the power of government, and then the Bill of Rights restricted what the government can do. It can't tell us what religion we are. It can't suspend our right to free speech. It can't suspend our right to freedom of the press, the right to bear arms. As mentions the 4th Amendment, the right to be free from unreasonable search or seizure. The 5th Amendment, due process. If the government's going to take property or put us in jail or so on, there has to be a fair system by which they do it. And then after the Civil War, they passed the 14th Amendment, which said state government can't restrict the rights of citizens as well, and prohibited racial and other discrimination. So the 14th Amendment wasn't passed until in the 1860s, so the first 60, 70 years, state governments were not governed by the Bill of Rights. They could restrict people's rights, and the 14th Amendment expanded that to protect us from our state governments taking away the rights that were given to us in the Bill of Rights. So administrative agencies, we're going to jump to that next because that's really a lot of what we get to later in this course. The brass tacks, the hands-on stuff is really done by agencies. And so the legislative branch basically creates an agency. Congress says we're going to have the Department of Agriculture. And the Department of Agriculture, we're going to have the Food and Drug Administration that is part of the Department of Agriculture. And the idea behind that is that these agencies are able to deal with the detail that goes into regulating society. Our DNR is a great example in the state of Wisconsin. Deer hunting is huge in Wisconsin. How do we maintain our deer population? The Wisconsin legislature created the DNR to manage the natural resources of our state. One of our natural resources is our deer, our wildlife, our fish, our game. And so how to make sure that we don't overhunt and basically destroy an entire species by overhunting or overfishing. Our legislature said we're going to create the Department of Natural Resources. These are going to be people who are experts in the field, who have a lot of education in the field, who have a lot of training. They're going to try to monitor the deer herd. They're going to try to monitor the fish population, and they're going to make rules on how many fish people can catch, how many deer people can shoot, in order to maintain our population, in order to maintain its viability. The legislature is really not suited to do that, so they basically hand it off. And the same thing with the way we regulate food production and food distribution, which is huge in the ag business. So agencies really do the detail, the minutia work, the finer the finer regulations of society in order to make things in order to make things function. There's the U.S. Department of Agriculture back in 1862. They created it, and then those agencies go on to make rules and regulations and so on. So when we looked at the three branches of government, the executive branch, the legislative branch, and the judicial branch, the legislative branch creates these agencies, but then they're run by the executive branch. So they're run by the president or by the government, or the governor in the state, in the situation of states. So we just saw President Biden initiate a slew of executive orders, all these executive orders. Basically, the executive orders are the president. We have a president from a different political party now, and this happens every time we get a new president. The president has a different political philosophy when it comes to what administrative agencies should be doing. The executive orders are basically directives to that agency. Here is what I want you to do now. The previous president wanted you to do something different, wants you to go in a different direction. This is what I want you to do now. And that is within the president's prerogative, because the president is in charge of the agencies. Now, we may have some challenges to President Biden's executive orders. That would end up going into court. Someone could argue, President Biden, you exceeded your authority to issue an executive order regarding, he just issued an executive order regarding the immigration. He suspended deportation. Somebody's going to argue that. It already was argued in court. A Texas judge said he exceeded his authority. Now that'll be appealed to the Court of Appeals, the U.S. Court of Appeals, that may make it to the Supreme Court. That's how our system works. If you think the president exceeds his power, you can take it to court, and we end up in the Supreme Court, potentially. So that's how our system works. Agencies are run by the executive branch. The president appoints the heads of the departments, the Department of Defense, the Secretary of State, and so on. Those folks are approved or not approved by the Senate. And then there's a whole bunch of other folks that get appointed that aren't approved necessarily by the Senate. That's up to the Congress. When they create an agency, they decide which people in that agency must be approved by the Congress. That's in our Constitution. And then really the policy goes forward. And as long as that agency acts within the authority given to it by Congress, they can change policy. They can decide they want to be more strict with the enforcement of environmental regulations. They can decide that the DNR can decide that we're only in this particular lake. You can only catch one walleye, and it's got to be between 20 and 27 inches. You might not like that. You can argue it when they make the rules, but the agency ultimately has the decision-making power, and that power was granted to it by the legislature. And so that's how agency law works, and we deal with a lot of that in ag law. So there's a couple different types of agencies. One is something known as an independent agency, and the other one would be known as an executive agency. An executive agency is what we just talked about, where the policy is made by people appointed by the president, and they're at-will employees. So if they don't do what the president wants, the president can fire them. Okay, the president can just say, you're not doing what I asked you to do, you're out. Executive agencies, in other words, can be very political appointments. Independent agencies are a little different because they're appointed by the president, but the president can't fire them. In fact, our DNR used to operate that way in Wisconsin. I'm going to say back in the 80s. I'm not positive. It may have been an elected position or it may have been an independent agency. In other words, the head of the DNR was appointed by the governor, but the governor couldn't fire them. And we do that for a couple of reasons. The Federal Reserve, which really manages our money fund, the interest rates and so on. The CFTC is also an independent agency. We don't let the president terminate the person who's appointed. They have a fixed term. I think the Federal Reserve is 6 years. The idea behind that we can explore it further. But let's have a conversation about that, whether the DNR should be an independent agency, because some things we really don't want to be political. The Federal Reserve really has a big say in how our economy operates, and maybe we don't want that political. We don't want the Federal Reserve to cut interest rates right before an election just so the unemployment rate goes down. We want the Federal Reserve to manage our economy in a way that is good for our economy, not good for the president. Right? We don't want the president to be able to manipulate the economy just for electoral purposes. And so maybe we can talk about that with regard to the DNR in Wisconsin. Judicial agencies operate under the Federal Judicial Center and the admin office of the U.S. courts. Those are agencies that are also non-political. They're appointed for terms. And then there's congressional agencies that are also really non-political, the Library of Congress and so on. So the rulemaking process. Now, there could be a role for some of you in this depending on where you go in your career. Because obviously administrative rules can have a huge impact on ag business. And so being involved in this, being aware of what is going on in your particular field could be something that you do depending on where you end up. Individual farmers may have, may want to keep track of this. Maybe they're part of a group that keeps track of whatever USDA regulations are coming down, maybe regulating what organic food is, regulating the dairy industry, looking at price supports at the state and federal level. And so if you're involved in managing ag business, keeping abreast of what's going on would be very important part of your job, and maybe you're part of a group that keeps track of this. But the steps are fairly similar. This is the federal steps. But basically, there's a rule that we're going to change a rule. That gets reviewed. It's similar in the state. There's a notice that there's going to be a rule change. We're going to change. I remember a few years ago, mourning dove hunting was a big deal in Wisconsin. Very controversial. They proposed to allow mourning dove hunting. They put notice up. They had meetings around the state where they got comments. Written comments were also provided. And then that agency reviews the final draft, and then the final rule is published. The one thing that's missing in all this, that's different than passing a statute or legislation, is there's no vote by the legislature. There's no veto by the governor. Basically, this is passed and passed by the agency. Now, Wisconsin does have a review process with our legislature. And so the legislature, I believe, can overturn an agency rule. And I'm going to take a look at that. I can't remember exactly how that works. So we've got this formal process, and it gets more formal with public hearings. If you're interested in being part of that, you can sign up to testify in Madison. Now it's probably virtual. To make comments. This is going to negatively impact my business, or this is good for my business. I mean, making rules about organics allows me to sell something as an organic, and that allows me to increase the price of it. So there's, sometimes people are in favor of more regulation. So sometimes you could actually write in, or you could actually testify at a hearing. Rarely do we do this exempt where there's no public comment. That creates a lot of controversy. People want to at least have some input. So most of the time, we're going to have a formal or an informal rulemaking process. If you think that the rule that was passed exceeded the agency's authority, then you can challenge this rule in court. So people who are affected by the rule, a farmer who's affected by this new rule, they can look at the statute that created the agency, and they can, obviously hire a lawyer. It's probably more likely a group that did this, to say that that agency exceeded their authority, or they didn't follow the procedure. So if somebody skipped a rule, they didn't post notice properly, You can challenge this. Constitutional challenges are probably rare. Usually it's either the actions beyond the scope or the procedure wasn't followed. And there you get a court to declare that rule is not enforceable because the agency either violated their authority or didn't follow procedure. So you can also challenge if you are ordered to do something by an agency. Maybe they find you're in violation of a particular rule. You can argue that in an agency court and go through agency law and say that this rule affected me. I don't think that the agency was factually correct. I didn't actually violate the rule, or the agency misinterpreted the rule, and go before an agency law judge. There's issues there because the agency law judge is employed by the agency, so maybe some bias. But the good news is you can appeal that. And these are the federal rules. Our text is largely federal, and I try to bring the Wisconsin state rules in where appropriate. And the same is true in Wisconsin. You can appeal an administrative law judge's ruling to a trial court, circuit court, the county circuit court, if you think that the administrative law judge ruled improperly. So, as you're probably familiar with, what do agencies do? Well, there's lots of programs, federal programs and state programs. There's lots of state-owned property and federal-owned property. Maybe you can participate in a grant, getting grants. We do that. I'm on the Village Cleveland Plan Commission, and we apply for grants all the time from various agencies, getting permits, to maybe engage in organic farming, to engage in fish aquaculture, what's it called, aquaculture, and then also they come out and inspect various operations, and will, if in the event that somebody's violating the rules, they can issue fines and enforce those rules. So how do we limit the power of an agency? Well, there are limits on it. Not only based on the statute, how much power did the statute give that agency, or did they violate the executive order from the governor or the president, if it's federal, and we can also go to court. So we have a variety of ways that we can limit agency power. And indeed, if the legislature believes that they don't want an agency, engaging in a particular activity anymore, the legislature could pass a law that limits that agency's power, that takes away the agency's power in a certain particular area, and make it a statutory ruling. For example, the IRS doesn't get to set the income tax rate. Now, the Congress could give that to them, but they don't. And so they can give them the power, and they can also take it away. So that's another thing that can be done to limit agency power, is to lobby a state legislature or the Congress and say, we shouldn't let agencies be making these decisions. This should be set in stone by Congress. And so that's another way to rein them in. Another thing that we have to deal with in our country, so we not only have federal, we not only have state government, but of course we've got county government and we've got municipal government. So in Wisconsin, you've got to deal with the county of Manitowoc, the county of Sheboygan. You've got to deal with the rules and regs for the villages as well, village or townships or cities. One that hit home, I wanted to start making honey. And I talked to our village clerk. I said, I'm thinking about doing a beehive and making my own honey. And I find out that the village of Cleveland has a regulation that prohibits the keeping of insects that are venomous. So you can't keep bees under her interpretation. Of course, now I could challenge that and say bees aren't venomous, but I think they kind of are. And so I can't keep bees in the village of Cleveland. Now, what I can do is I could lobby to have that rule changed, because I think it's, well, I don't like the rule, and I don't think it makes any sense, and especially when bees are suffering, and bees pollinate and so on and so forth. So I could move to change that, but that's an example of where, somebody who wants to get involved, and I wasn't going to do a business, but you can be impacted by local government as well. So that's where if I was to keep bees, I would end up violating the local village ordinance, and I could be fined. There's some penalty with the local ordinance. So you've also got to be aware of county and municipal regs as well. Common law I talked about earlier. We're going to spend some time on this in the future, so I'll go over this fairly quickly. But as I said before, it's judge-made law, and so we look at decisions that were made in the past, and it's important, if you really want to have an in-depth understanding of the law, you need to read cases, because statutes are subject to interpretation. Different words can mean different things to different people. And so at the end of the day, when we have a dispute about what a word means, and that dispute would impact the outcome of a case, we end up in court arguing it and going from there. So we've got this common law where certain areas of the law are created by judges. And that happens to statutes. It happens in areas where it's just made by the judges. But it's something to be aware of, that in order to really understand the law, you've got to read court decisions, because they interpret what those words mean in a particular situation. And also, getting a little bit more down in the weeds, what a California state court says doesn't matter to a Wisconsin state court. So that's different judicial systems, different jurisdictions, you want to use that word. Federal courts apply to Wisconsin, but other states don't apply to Wisconsin. So you can read those cases to get a better understanding, but a Wisconsin court judge can say, I don't care what California does, I'm going to do it Wisconsin. What I think is right in Wisconsin. When we're going to go to court, we're under Article 3, and this is some fairly in-depth legal stuff that may be beyond the scope of this class, but the lawyer that wrote the book put it in there, so we've got it here. Basically, if you're going to go to court, you've got to actually have a real fight with somebody. You can't just go to court and say, hey, if this happens, or if I do this, will I get in trouble? You've actually got to have a real set of facts, a real set of circumstances. So that's this first part here, no advisory opinions. Our state Supreme Court does not issue advisory opinions. If you ever do want an advisory opinion, you go to the Attorney General. The Attorney General is the chief lawyer for the state of Wisconsin, and you can ask the Attorney General, if I did this, would that be breaking the law? Okay? And the Attorney General's advisory opinion is just that. It's only an advisory opinion. But you can get some advice on, what a hypothetical situation is really what it's all about. So I was talking about this before. You start in the trial court system. That's where you file your case. I've got a fight with a neighbor over where the fence is, or it's a nuisance case because they altered the lay of their land, and now their water's flowing into my property. So we start in a trial court. We have a federal and a state court system, so it's split into two. And there's federal law, U.S. constitutional law, and then there's state law. and you would file your, if it's a state law case, you file it in a state court. So that's an initial consideration. And then the process is you've got to get served. So if you ever heard of a summons and a complaint, that's basically the notice that you are being sued. You got to answer them, even if it's a really stupid case. Because if you don't answer it, the judge